Good evening. This is John Milburn for Laws 12067 Environmental Law. This is week 8 of term 3, 2017-2018. We have some people online. Thank you very much for attending live. For those of you that might be undertaking this unit and not attending the sessions, I encourage you to do so. I also encourage you to engage in discussions through UCrew and to answer the weekly questions. All of that will help you towards the end of the unit. The unit is subject to evaluation. My work is subject to evaluation, and I encourage you to click the big red button that will appear, if it hasn't already appeared, to provide feedback to the university. That feedback is very important to the university. It's very important to me personally, and I'd appreciate if you could take some time to provide that feedback before the end of the unit. So tonight we're covering a wide range of material. And in many ways, the material that we're covering this week, which relates to chapters 12 to 18 of Bates, and the protection of biodiversity and climate change, is at the core of what most people see as environmental law. So we're covering a huge range of material in 1 week. If you've undertaken your reading, you'll know that there's a lot to cover. I encourage you to move fairly quickly through the material. There's too much to read in great detail, but take from it what you can. Now, looking to tie the material this week with what we've done previously, you'll be aware that environmental impact and its assessment is a core feature of environmental law. And this regulation is done at the administrative level through government. And we have, of course, Parliament, which provides the formal legislation. We have the government that provides regulation and decision-making processes and implements what Parliament has provided. And the courts, of course, who do not involve themselves in determining policy, but deal with judicial review and merits review matters. And we've dealt with those in previous weeks in this unit. So tonight, we're dealing primarily with the executive, with the second level of government, if you like, and it's where the policies are implemented, plans are put in place, and the regulation is a process which drives environmental law. So we're dealing with that mostly tonight. So not so much parliamentary issues and not so much court issues. We are, of course, as always, dealing with the levels at state and federal. And the key pieces of legislation that we'll cover at a Commonwealth level relate to the EPBCA, the Environment Protection and Biodiversity Conservation Act. And at a state level, we'll be dealing with a number of different pieces of legislation, and we'll go through that. Now, I mentioned that we're not primarily dealing with parliamentary issues, but we're dealing with the way in which the executive uses the legislation which is provided to it in formulating policies and working around the protection of biodiversity and climate change. So it's essentially a resource management issue which is dealt with at a state level, at a federal level, but also privately, and that private aspect of resource management is sometimes overlooked. So somewhat out of order, let's have a look at the state level. And protection of biodiversity essentially means a conservation issue. So in Queensland, the government prepares and formulates plans, and those plans are used for conservation. Management plans relate to protection areas, and conservation plans relate to wildlife and habitat. Probably the most important piece of legislation that you need to consider, initially at least, in this regard from a Queensland perspective, is the Nature Conservation Act of 1992. Have a look at that Act generally. As always, when it comes to statutory interpretation principles, I encourage you to look at the Act in its entirety, looking primarily at the headings and getting a feel for the structure of the Act, and then drilling down from there. So the key section, if you like, in terms of regulation is section 175(2), and that is of the Nature Conservation Act. The reason it's important is that it enables regulations to be made to give effect to the management and conservation plans and enforce compliance with those. And consistently with this, Section 119, subsection 2 of the Nature Conservation Act provides that a conservation plan is what we call subordinate legislation. And you recall that Parliament can provide the executive with the power to make subordinate legislation. So management plans or conservation plans do not have effect until approved by the Governor-in-General. And the reason the Governor-in-General needs, Governor-in-Council rather, needs to provide its approval is because that is a requirement for subordinate legislation. Now, once the subordinate legislation is put in place, it becomes law. Therefore, it follows that there is a duty on local government to make decisions that are consistent with the conservation plans and the management plans that are developed through as subordinate legislation. At a federal level, we also have a number of plans that regulate the protection of the environment. The EPBCA, as mentioned, is the key piece of legislation. And you'll see from your reading that the EPBCA approaches the conservation of biodiversity from two perspectives. The first is non-geographic. The second is geographic. Now, what do I mean by that? So when we talk about the approach to conservation of biodiversity under the EPBCA from a non-geographic perspective, what I'm saying is that the value of nature is protected and may be affected by actions for which the approval of the Commonwealth is required under Chapter 2 of the Act. So it's the issue of protecting nature by approval through the Commonwealth as opposed to where the event takes place. Contrast that to geographical, where protection of the value of nature is an element in the nature of the management of an area within the Commonwealth jurisdiction. So marine environment, parks or land reserves, which are set aside as Commonwealth reserves. So the EPBCA provides protection either which is non-geographical based or geographical based. And have a look at Section 176 of the EPBCA, because that provides for a bioregional plan to be prepared for a bioregion within the Commonwealth, and the Commonwealth is then under a duty to implement a plan to the extent that the plan applies in Commonwealth areas. And that's Section 269 of the EPBCA. Now, the EPBCA enables a Commonwealth area to be a conservation zone so that biodiversity in that area may be protected while being assessed for inclusion in a Commonwealth reserve. Now, when we talk about geographical areas, there are some very specific examples, even going outside the EPBCA. And a key example of that is the Great Barrier Reef, which of course remains within the jurisdiction of the Commonwealth. And the Great Barrier Reef Marine Park Act 1975 is Commonwealth legislation that establishes the Great Barrier Reef Marine Park Authority, which is then under a duty to prepare zoning plans for the area. There is, as I mentioned, regulation that applies at a private level as well. So a developer may undertake planning for internal purposes, and the project planning includes putting in place procedures and systems to ensure compliance with any legal requirements that relate to a proposal in a location. Now, that process is primarily regulated through environmental impact assessment processes, which is what we discussed last week. All right, so stepping back for a moment, we need to consider planning policies, plans which are put in place, and a key element of invoking environmental protection and protection of biodiversity, which is through a mechanism called environmental offsets. So let's have a look at those now. From a Queensland perspective, let's have a look at the environmental offsets framework, which consists of acts, regulations and policies. And of course, this is administered through the Queensland Government. To highlight how this works in practice, I'm going to share the screen. Hopefully, you can now see a screenshot from a Queensland Government web page, and it relates to environmental offsets. So this is www.qld.gov.au, Environment, Pollution, Management, Offsets. So environmental offsets, as indicated, relates to acts, regulations, and policies, all of which are administered through the state government agency. The framework includes legislation, regulation, and policy. Let's have a look at that. Firstly, the Environmental Offsets Act of 2014 is a Queensland piece of legislation that provides the coordination of delivery of environmental offsets across jurisdictions and provides a single point of truth for offsets in Queensland. Please look at that Act, and when you do so, I'd urge you to consider in particular sections 3, which deals with purpose and achievement, 7, which deals with what is an offset condition and an environmental offset, and 8, which relates to what is a significant residential impact. That Act was amended on the 2nd of July 2015, and just remember, of course, that when you're considering legislation, you should look at the legislative history and consider subordinate legislation. The subordinate legislation particularly relevant to this area is the Environmental Offsets Regulation of 2014. That again has been amended. You can look at that history through the legislative history. It was amended, for example, on the 1st of July 2016. Now, the regulation works in conjunction with the Act, and it provides details of prescribed activities regulated under the existing legislation and prescribed environmental matters to which the Act applies. The third suite of material relevant to environmental offsets in Queensland is the Queensland Environmental Offsets Policy. You'll see that's current as at June 2016. And these are pretty easy to find, but you'll see this is through the EHP, so www.ehp.qld.gov.au, Assets, Documents, Pollution Management Offsets Policy. This is version 1.2, which has been updated to reflect the protected areas categories under the Nature Conservation Act, which were reinstated under amendments to that NCA in 2016. All right, I mentioned that when you're looking at the Act, you should consider sections 3, 7, and 8. They are the purpose and achievement of the Act, and if I can just stop this share screen, and I'll work that out in a second. All right, so when you're looking at any piece of legislation, it's always a good idea, I think, to look at the overall headings and get a feel for the Act in its entirety. Then I think it's a good idea to look at the objects or purpose clause, and you'll see in this case that the environmental offsets legislation is specifically enacted to establish a framework for environmental offsets, to recognise the level of protection given to prescribed environmental matters under legislation, provide for national, state and local matters for environmental significance to be prescribed environmental matters for the purposes of the Act, and then to coordinate the implementation of the framework in conjunction with other legislation. Section 7 provides for what is an offset condition and an environmental offset. And it provides some examples in the legislation. So you'll see that examples of environmental offsets which can be undertaken might relate to carrying out work to maintain the viability of a prescribed environmental matter, preparing a plan, or conducting scientific research. What this really means is that payments need to be made. So a payment of a financial settlement offset is made in lieu of undertaking certain things that might otherwise offend environmental offsets. So what we need to do is consider Section 8, determine what is a significant residential impact, and determine that if there is an adverse impact, which it remains or is likely to remain in place and is likely to be significant, then in simple terms, the proponent is required to make a financial settlement offset, and that is the offset that we're talking about. And that might be a condition for an approval, or it might be for providing for mitigation measures down the track. So to try and give this more practical context, if we have a situation where someone does make an application which then requires an offset to be made from a financial perspective, we need some idea of what this means in practice. How much do we have to pay by way of a financial settlement offset? The good thing is that the state government has kindly provided us with a financial settlement offset calculator. I'm going to share the screen and give you some idea of what this means in practice. So you should hopefully now see the environmental offsets policy that we were discussing. Let's look at the calculator. So this is through environment.ehp.qld.gov.au, and you have an opportunity by using this offset calculator to implement the environmental offsets framework, which is consistent with the environmental offsets policy, and you then have an opportunity to calculate the financial settlement which is required for an environmental offset, or a site assessment for impact matters or offset matters required for environmental offsets. And you'll see that there are templates and forms. What I'm going to encourage you to do is undertake some homework by clicking on the calculator, particularly say financial settlement, and working your way through that by answering a number of questions, hypothetically of course, and see if you can come up with some idea of what this is all about. So for example, if we're dealing with terrestrial or marine, we make a choice. If it's terrestrial, we select an area, let's say Cairns, confirm the selection, and then follow through, just hypothetically, and I'm just selecting at random now, and you'll see that it provides you with guidelines and information. And sometimes you need to drill down a long way, which is why I've encouraged you to just play around with this. And again, I'm just selecting purely at random, and I'm not going to get a result easily. So I'm going to abandon at this stage. But I'd encourage you to do that because it's quite extraordinary, some of the figures that you come to, and give it some, unlike what I've just done in that simple demonstration, give it a little bit of thought, because as you work your way through the system, you can see what are the important factors. And it's really important to try to tie this in from a practical perspective. It's all very well to talk about these financial offsets and have them as theoretical base, but by actually using the calculator, it will guide you to the relevant pieces of legislation, to the relevant principles, and ultimately come up with a figure. So if you're going to be advising clients in terms of a development or proposed development, it's critical that you give them some advice in relation to the offset situation. That's the Queensland perspective. From a Commonwealth perspective, as mentioned, you need to look at either the activity or the geographical area. Let's have a look at, say, marine reserves, which are administered through the Department of Environment and Energy. Once again, I'll share the screen in order to highlight what this means in practice. Please let me know if I've highlighted the incorrect screen, but now you should be seeing the Australian Government Department of the Environment and Energy Australian Marine Parks website page, which deals with issues to do with management arrangements for reserves in Queensland. Now, this is undertaken through the department as a result of power conferred upon it under the EPBCA. The Environment Protection and Biodiversity Conservation Act provides for the proclamation and management of Commonwealth reserves, and these reserves proclaimed under the EPBCA may relate to terrestrial reserves, which are national parks and botanical gardens, or marine reserves, which are marine parks or marine reserves or nature reserves. So the Director of National Parks, and you'll see there a reference to the Director, is the statutory authority responsible for the administration, management and control of all Commonwealth reserves under the EPBCA. So the functions of the Director include providing protection, conservation and management of biodiversity and heritage in these Commonwealth areas. Remember, of course, that the Great Barrier Reef has its own legislation, the Great Barrier Reef Marine Park Act 1975, which is specific legislation dealing with management of the park through the Great Barrier Reef Marine Park Authority. Another thing that you'll come across, and I'd like you to consider with some degree of importance in your reading, is Ramsar wetlands. Now, all of this, Ramsar is R-A-M-S-A-R. Ramsar wetlands come into place as a result of the Ramsar Convention, which is the short version of the Convention on Wetlands of International Importance. It is an intergovernmental treaty that provides the framework for the conservation and wise use of wetlands and their resources. So the Ramsar Secretariat supports the parties to the convention. So we're now talking international law in that context. All right, so coming back to the federal level, one of the important things that you need to consider from a practical point of view are what we call conservation agreements. I'm going to again share the screen. And for information about conservation agreements, have a look at the Commonwealth Government Department of Environment and Energy website page. It explains what is a conservation agreement. It provides what it may do, and it gives some idea of how this is put into practice. Again, this is provided through authority under the EPBCA, and the Commonwealth, a conservation agreement is essentially this. It's an agreement between the Australian Government Environment Minister and another person for the protection and conservation of biodiversity in an area of land or sea. In order to better understand this, you really need to look at the list of conservation agreements to get a feel for how this works in practice. So the conservation agreements under the EPBCA, let's see if I can bring this up. Okay, so there is a list here of, there it is, conservation agreements under the EPBCA. So, for example, we have a conservation agreement for the protection and conservation of grey-headed flying fox at Bateman Bay in New South Wales. And if you look further down, close to where I practice, we have the management and protection of EPBCA listed species at Hervey Bay, then the Sunshine Coast. So a lot there from Queensland and New South Wales. That we have the Tasmanian Forest Agreement, etc. So that gives you an opportunity to see what these things are like in practice. So the conservation agreements may be very specific, and they are binding not only on the person who entered into the agreement, but also on successors to any interest in title. So you need to be aware of these things if you're advising a client who may, for example, be seeking to acquire property, which is somehow subject to a conservation agreement. I guess what may then come to mind is this. It's all very well to have these conservation agreements, this set up between the Commonwealth Government and another person for the protection of biodiversity and conservation of an area of land or sea. But how do you enforce these, and who can enforce them? Well, under the Act, Section 476 of the EPBCA provides that conservation agreements can be enforced through an application in the federal court, where the court has power to injunct a party which is in breach of a conservation agreement. And we'll talk more about that in later units in this course, or weeks during the course. Right, so that's the Commonwealth level. Let's go back to the state level. You'll be aware from what we've discussed already tonight that the Nature Conservation Act is, yes, and so standing is available to anyone who wishes to challenge. Now, that was subject to some discussion with Senator Brandis last year, so I will need to double check what's the latest on Section 476, but it was open-ended standing in terms of seeking an injunction through the federal court. Right, so at a state level, we have the Nature Conservation Act, which is provides for a declaration about achieving conservation strategies that protect particular areas of biodiversity conservation, biological diversity, and natural features and wilderness. The other important piece of legislation at a state level is the Biosecurity Act of 2014. I'm just going to share the screen. And again, hopefully you are now looking at that screen. If I've hit the wrong button, please let me know. So the Queensland legislation, in-force legislation, includes the Biodiversity Act of 2014, and there it is. It commenced on the 1st of July 2016, and it ensures a consistent, modern, risk-based and less prescriptive approach to biosecurity in Queensland. So what this Act does is provide measures to safeguard the economy, agriculture and tourism, the environment from pests, disease and contaminants. It's very interesting that in the purposes of the Act, it specifically says that it's not just about protecting the environment. This is a common theme in environmental legislation. In order to comply with issues to do with ecologically sustainable development, issues to do with the economy, agriculture, tourism are also relevant factors. Now this Act, the Biosecurity Act 2014, replaces many separate pieces of legislation that were previously used to manage biosecurity. So this is now the key piece of legislation for consideration. Offenders can be subject to remedial orders as well as criminal prosecution, generally speaking. Again, based on Queensland, let's have a look at the, looking at the federal level, let's have a look at the federal government's native vegetation framework, and I apologise that I'm bouncing between state and federal. So this is environment.gov.au, Land Publications Native Vegetation Framework. And the Native Vegetation Framework came about as a result of a COAG Standing Council on Environment and Water 2012, and that is the key body for administering these areas of practice. So the Department of Environment and Energy administers the Native Vegetation Framework. The intent is to increase the national extent and connectivity of native vegetation. It's national framework to guide ecologically sustainable management of native vegetation, and it provides regulatory control over land clearance in some ways. You'll recall a case of Spencer against the Commonwealth from 2008, Federal Court of Australia 1256. Just speaking about the issue of land clearing, in that case, Spencer argued that the prohibition from clearing his land without consent deprived him of an ability to reasonably use the land, and argued that the state could enact vegetation legislation based on Commonwealth financial assistance. He was deprived of a right, and there was no just compensation payable, but that appeal to the full federal court was dismissed. In Queensland, the Vegetation Management Act 1999 was passed, although Queensland government threatened not to pass the legislation until the Commonwealth met demands from private landowners for compensation. Just on that point of vegetation management in Queensland, have a look at the Queensland website that deals with vegetation management. That's www.qld.gov.au, Environment, Land, Vegetation and Management. And this website provides information about whether a proposed clearing activity is exempt or may be undertaken in accordance with self-assessable code requirements or requires a permit. Now, for native wildlife at a Commonwealth level, the Commonwealth is bound in some ways by international conventions. And when it comes to protecting endangered species of wild fauna and flora, the Convention on International Trade in Endangered Species, CITES, is important. This website, which is www.cites.org, provides information about the convention. And you'll see that there are a number of specific international issues that have been agreed to by the Commonwealth, which become eventually part of our law. So when it comes to native wildlife, people may not take action, which is going to have or likely to have a significant impact on listed threatened species. Have a look at section 194Q of the EPBCA, which provides for penalty ranges. Now, those ranges are significant. If we're talking about issues to do with breaching Commonwealth laws and improperly dealing with endangered species of wild fauna and flora, if you look at section 194Q, you'll see that the maximum civil penalties range from $550,000 for individuals to $5.5 million in the case of corporations. These are expressed in penalty units, 5,000 and 50,000 respectively. Courts impose substantial fines. You'll see from the material that we've presented that in the Minister for the Environment, Heritage and Arts against Lamantina, which is a 2009 federal court decision, the order was for an individual to pay $220,000 for clearing native vegetation. In the Minister for Sustainability, Environment, Water, Population and Communities against De Bono, which is 2012 FCA 643, the respondent was ordered to pay $150,000 for clearing, ploughing and rock removal that had a significant impact on a threatened ecological community. And the respondent was also required to enter into a 5-year management plan. So that ties back to those management plans that we talked about, which involve an agreement between government and individuals. So I've mentioned a couple of times the Nature Conservation Act in Queensland, the importance of it. How is that administered in practice? Well, again, because the focus of what we're talking about tonight is all about the second level of government, which is the executive, it comes as no surprise that we once again refer to a website page for a department, in this instance, the Department of Environment and Heritage Protection. So this department is responsible for administering the Nature Conservation Act. It deals with issues to do with protection of wildlife through licensing and permit regimes. And in considering the regulation and protection of wildlife and ecosystems, the department implements policies with respect to threatened species. Those policies are listed here on the web page, and they deal with a number of issues, including, for example, pollution control, etc. When you're considering these issues, bear in mind that it may be that regulatory authorities choose to prosecute as criminal prosecution or take some other action. And one of the actions that we've seen and discussed are management plans entered into between the individual and the government. Now, what happens if a person commits serious environmental harm? What is the relevant legislation? What are the courts able to consider? And how do they deal with issues? Well, the important section and the act that's relevant is the Environmental Protection Act 1994. Queensland, have a look at section 17 that defines serious environmental harm. It's essentially something that is harmful to the environment, which is irreversible, of a high impact or widespread, or caused to an area of high conservation value or an area of special significance, such as the Great Barrier Reef Marine Park. And it causes actual or potential damage to property, which is more than the threshold amount and results in costs more than the threshold amount being incurred for prevention or minimisation of harm. The threshold amount for serious environmental harm is $50,000. So what I really want you to do for this area of practice is consider the Environmental Protection Act, have a look at section 17, serious environmental harm, and consider a couple of cases. The first case is the case of Bergen against Link Energy, which is 2016. It's a Magistrates Court decision, QMC 4, and it's a decision of Magistrate Ryan at Dalby. Now, the task of the presiding magistrate in this case was to determine whether there was sufficient evidence to warrant the defendant being committed to trial in the district court with respect to a charge brought against him pursuant to section 17 of the Environmental Protection Act. In that case, this case of Bergen against Link, the magistrate did find that the widespread nature of the alleged harm to the environment was sufficient to satisfy the threshold test and accordingly did commit the defendant to trial in the district court. Just to digress there, if you've done criminal law, you'll probably be aware of what's meant by a committal. and what is the test for a magistrate in determining whether or not to commit someone to a higher court. Basically, the obligation on a magistrate is to determine whether, at law, a properly instructed jury could convict the defendant. Not would, or even would be likely to, but could convict the defendant. So the threshold is not high, and many people are committed to trial, even though many of them may be acquitted, or many of them may be subject to no evidence being offered against them if there's insufficient case to actually secure a conviction. So that's Bergen against Link Energy, 2016 QMC 4. The other case that you might want to consider is a Planning and Environment Court decision, and that is a decision of Crowther against the state of Queensland. It's an earlier decision, 2002 QPEC 79, and the applicant in that case sought to restrain an offence alleged to have been committed against the Environment Protection Act, and did so by bringing an application to the P&E Court pursuant to section 505 of the legislation, which provides for the court to be able to provide a remedy or restraint by someone who is threatening or anticipating an action which is an offence against the Act. And in that case, the applicant successfully sought a declaration that airborne emissions generated by the Yeronga TAFE amounted to environmental nuisance, and an order restraining the respondent from allowing the environmental nuisance to continue. This is a decision of His Honour Judge Robin, QC. I'd refer you to paragraph 28 initially, where His Honour said the following. No, I'll need to revise that because I'm not seeing the quote that I was after. I'll just stop the share for a second. So what you'll see in that case is that Judge Robin essentially defined environment and did so in broad terms. And we're dealing now with an unpleasant odour about the quality of a place and hence the environment. And it was an unreasonable interference in His Honour's view. And it was for the respondent to avoid trouble by showing that the general environmental duty had been complied with. And the court held that whilst it is unusual to contemplate an injunction against the state of Queensland, it was conceded that one could have been ordered, and enforcement of injunction does present some particular problems, but the court was prepared to grant the relief that was sought, and the court said that it was a clear case where it was necessary for the court to essentially send a message to the effect that a party, including the state government, that might be causing environmental harm, including an environmental nuisance, may be subject to sanction and an injunction by the court. So sometimes it's difficult to differentiate between that which is civil and that which is criminal. Essentially, individuals have an ability, as we saw in the Crowther's case, to bring action seeking a civil remedy. The most important civil remedy that is available is an injunction. And an injunction is a civil remedy which effectively is an order of the court to stop someone from doing something that would otherwise amount to environmental harm. Criminal law proceedings are generally brought by regulatory authorities, and one difference between the civil and the criminal is the burden to which the prosecution is required to fulfil. So in criminal proceedings, prosecutors must establish beyond reasonable doubt the guilt of the defendant, as opposed to civil matters where it's on the balance of probabilities. You will see from time to time some reference to the Briginshaw approach, which means that even though in civil proceedings it's on the balance of probabilities under the Briginshaw principle, if there is serious consequences that flow as a result of a particular matter, then the court is entitled to ask for more and better proof to establish the balance of probabilities. So the test doesn't change, but the obligation to provide better and more cogent proof does. So it's not essentially an estoppel situation. Estoppel is something quite different in that we're talking about someone going back on something that was said or implicated. An injunction is really an opportunity for a court to put a stop to something which is either being done or proposed to be done. Now, I know I've covered a lot of material this evening. Thank you very much for your patience. And those of you that are watching this at a later stage, I hope that you can work your way through the material. What I've tried to do is extract the important parts of chapters 12 to 18 in a manner that ties it in with the website pages of the appropriate regulated authorities, both at a Commonwealth level and a state level. I'd urge you to look at the websites, undertake some practical work such as the offsets calculator that we discussed, and hopefully that will tie it in a more practical sense rather than just simply considering the theory. All right, unless there are any questions, I'll end the session now. Thank you for attending, those that have done so live. And please, as I mentioned at the start of the session, I encourage you to generate some discussions through UCrew. Ask any questions of me or your fellow students. If you come across something that for example, I haven't touched on tonight, that you find is valuable, a useful link, case, website, please share that with others by establishing or by posting something on the UCrew site. All right, well, I'll end the meeting now. Thank you for your attendance, and we'll see you next week.
Thanks, John. Much appreciated.
Thank you, Kim.
Very good. Thank you very much. Good night, Scott.
Good night. See you later, John. See you.
See you then. Bye.
Hooray. Thank you.